Comments are first in a series of educational seminars. As I said, it's in person and virtual. The format we'll do is each of our three presenters will do a short presentation. Then we'll follow with some question and answer from the audience. We've already during your registration received a number of questions, so we have some start of the conversation that way. We'll show you in a moment. Can we advance the slide? Yeah, we're here. So as you can see throughout the slide, you'll see the QR code. If you capture that with your phone, it will take you to an app called Slido, and you can go in there and enter questions, and they will come to my laptop, and I'll manage it that way. After the Q&A, we'll have some light refreshments and networking. We're also going to have a virtual networking, so a couple people from our innovation team will make themselves available to anybody that's online that wants to have some continued, more one-on-one discussion, and we'll see how well that works. We are recording this. We will post a recording onto our YouTube site and also to our webpage. And very importantly, we will be sending a survey to everybody who's attending, and it's important to us, as I said, we're going to be doing a series of these. Please give us your feedback. What was good, what could be better, what we can get rid of. We're really doing these to be valuable to our customers, inventors across the system. So with that, we'll go ahead and get started. Our first presenter, first let me say thank you to Lekha, Gopalakrishnan, except that she was not available for me. She had a family emergency, could not attend. And I'm even more appreciative of Mark Kelley. Many of you know Mark as the contract attorney, part of OGC, sits with our innovation team, such a valuable part of our team to help us work through legal issues. But Mark's background is he's a patent. And so today, Mark is going to talk about the patenting process and how patents help us deliver value in our commercialization.
Hi. I'll talk a little bit about what technology transfer system 101 brings. So, what technology transfer offices kind of do is take your ideas and get it to market. You have to have an idea first, right? And you're going to take your idea and lead to basic research. The basic research leads to invention, hopefully. But you got to remember, sometimes vendors can also lead to inventions. For example, remember these two guys who invented this adhesive that didn't do too well. Trying to be Post-it notes. So it was a film production run, but it actually turned out to be very useful. So what they do, technology transfer offices like one Texas A&M Innovation, they license technology to companies. Also, they assist in creating startups. And it could be with a professor, or it could be a startup from the system like here. So what is technology transfer before? It used to be just a background stuff. Now it's going to be merged into the program. Everybody wants to have more technology transfer going on. So, a long time ago, in a place far away called DC, the federal government used to own all the inventions when they gave money. It's not very helpful to try to get anything produced across the market. So in 1980, they came up with the Bio Act, which allowed university to select ownership or elect ownership in their own IP. Also, it helps stimulate the economy by getting things off the marketplace. But of course, then you have anything that you do, there's the share codes. So, of course, when you have a new invention, you got to disclose it to the federal government. 60 days of the invention, disclosure. You have 2 years to enact, what if you don't know like times this. And 1 year after, within that 2 years, once you elect, you have 1 year to file patent in the US or overseas, so like ACT. Then the technology transfer office is going to try to license this to the commercial company, get it out there to the marketplace. Any revenues that come in, be with the matters, go back to the matters and also to the university. And also have to support research and education, that's all provided. So like I said, undivided universities get the ownership for federal money. It also creates job sectors. This is kind of what I said before, but one thing I want to add is that anytime you create some startups, a lot of it tends to be local. And there's a one bottom survey that came out on that 70% of startups are started up right locally with universities. So you have viability and invention. So the question you have is this patentable? Is there a market for my question? Or for businesses, how do we fund businesses for licenses? We start a new company. There's any money to start a company to do this. Well, that's what technology transfer offices to do. They have actually started. And people who analyze the marketplace, understand technology, get it out there. They have attorneys, including outside counsel and patent prosecution. You have experts who know about angel capital, venture capital. They have campus-based accelerators with us, and we also have some resources that help you in future development of technology. But of course, this is who's an inventor. To have an invention, you have to have what's called conception, reduction, and practice. Conception is you have to have more than just a basic idea. You can't say, hey, I'm going to operable. That's not enough. You're going to know how to make it how to make it work. Then you have reduction and practice. You have two types of reduction practice. Either have actual reduction, you actually make the product, or you have constructive, where you actually file patent application. So when I sent them to this, perpetual motion machines. Believe it or not, I had a question when I was in practice. I've got to say, perpetual motion machine, I'm all about. I said, did you build a product? Federal government requires you to build a product because they don't believe any perpetual motion machine works. So you have to prove it. And each inventor must contribute to what's called the conception of invention. But you don't have to contribute to the actual reduction practice. You can farm out some reduction practice and building it. And also, each inventor has to contribute to each and every claim. As you're probably aware of, a patent has a background, specification, with figures, and claims. Claims are the ones that protect your invention. So, all you have to be is the inventor of one of the claims to be considered a joint inventor. And it all goes through the subject matter of the claims are. So, for example, you may have an invention and it's on a patent trademark office and says, you got two inventions here. You got to separate. That's usually done by what we call a visual. So you may be an inventor on one that's in one patent, but not an inventor on another because you were titled as one thing, that same claim is on the other. So that can happen. Or, for example, during prosecution, you may be an inventor for the dependent claim, that dependent claim has to get taken off, be allowed to be taken off by the inventor for patent. Perception, like I said before, can't be just based out there. You have to clearly understand your whole invention, all your start to finish. It doesn't have to work. You just have to understand everything completely about it. Because the court wants you to say, I had this whole thing, I just said the hoverboard. You just can't say, I got a hoverboard and I'll patent on it. But it's something, you have to explain how you make it, I would say, what's the ball for making it, and so on. Now, here's the big thing where it's mixed universities. Mentorship versus authorship. Just because you're an author or paper does not make you an inventor. A lot of people put their chairman on, the board chairman on there, they put their, if you're doing a grad student, they put the professors, in charge of the thesis, and all these things on here. And sometimes they add students who do research for them, who just run tests. Not anyone needs to be an inventor. You haven't heard that. Can change.
So can you advance?
Joint inventors. We have two more inventors on the record, 35 and 16 requires each one be conceived, be part of the seed of the main invention. And then you can't just insignificant. Say, hey, I'm part of this, but I think you should make that color, make that a yellow color. That's not the big thing. Has to be something more significant than just changing colors. There's also inventors can work remotely. For example, maybe somebody here, maybe somebody in another university is working on different parts of the invention. They don't have to be in the same room to work on. And under patent law, the same ownership follows inventorship. What do we mean by that? Just take the group of inventors, and then you check to see if there are any requirements to that inventor to sign to somebody. Here at the university, everybody has to sign like this is it's not so your research or what you're doing, you're hired to do. But remember that if you do consulting work, be careful because in consulting work, you may have to sign something to that company work. The other thing you just want to make sure we have to sign that's well drafted, covers all the different agencies you do. A lot of that's up there, which I'll leave that up. Some of the key takeaways is you need to discuss the mentorship very early in the process. We need to know who the vendors. Don't know who the vendors are, you got a problem. Also, talking to all the vendors and having more functional intervention to help get around our things that we've been out of. It's kind of hard to see these slides. So the other thing you need to do is anytime you have the exchange of membership, you need to notify us council. And both all agreements, for example, if we're working with another university, we have inter-institutional agreement between us and the other university, saying who owns the invention, how to share revenue, and and so on. You need that discussion ahead of time. So here's the typical patent process. Right here, we tend to follow our original patent application. Once you file it, you have 1 year to file non-provisional. You need to file by the US patent application or PCT, which goes overseas. And if you go overseas, it delays it 30 months before you get a decision. So you file licensing. You still come back to the US. Here's the thing to remember: in the US, it's going to take 2 to 3 years before you get an office action of the patent and trademark office. And don't be surprised, the very first office action is everything's rejected. That's not. They reject anything the first time. Very rarely do you get something allowed the first time. I've done it once. And then I realized, oh, I claimed it too narrow. And then you got allowed. So they claimed it too narrow, they made the issue. But then, outside counsel has to argue with patent office why it should be allowed, and then it goes back and forth. And it takes some time through this process. Take a couple, or it can take 5 or 6 years. It varies. Hopefully we get to an allowance. One here's AI is pretty new. One thing to remember, you can't patent AI, which has to be a human being. Same thing for hardware. Hardware so that anything that's developed or wrong by AI is not copyrightable. You can't copyright something that has the opportunity to fund just from that. So all those fellows are going to have to use it. So if you have any questions, start me, contact data. Again.
Thank you very much, Mark. In addition to jumping in, Mark did a great job going through patenting very quickly. I've been to many talks where going through the details of how to get a patent can take an hour or multiple hours, and people make a career out of that. We wanted this discussion to be a little bit more than just how to get a patent. And so next we have Dr. Travis Young from Sponsored Research Services. In my short amount of time here, I've had a real privilege to work with SRS and others who manage sponsored research across the system. I understand the perspective of researchers that I care about the research. I don't care as much about the IP provisions. I assure you that your sponsors care about the IP provisions, as evidenced by the language that they write. So it is Travis's job and so many of the other people that work with Travis to do the good work on behalf of you as faculty and the Texas A&M system to make sure we get the best, most fair language possible with our sponsors. So I'm pleased, Travis, thank you for being here and to go through sponsor research. Thank you.
Turn this on. I think we're ready. You hear me? All right. So, as Pete mentioned, I'm going to talk a little bit about intellectual property interacts with sponsored research. I think that's right. That was wrong. There we go. So basically, in sponsored research agreements is what SRS deals with, other contract offices on campus, the T's contracting office, AgLab, so forth. We all deal with these research agreements when a sponsor wants to come and sponsor research at A&M. And typically, the IP provisions in these agreements deal with two main things that they want. Typically, the things that can cause issues, they want ownership, which is basically they want to have control, sole control of any intellectual property asset that comes up. Or they want some kind of license to it. They say, okay, if I can't own it, I want to have an exclusive license where I'm the only one who can do anything with it. Or sometimes they're okay with non-exclusive license, which is basically I can use it, but you can give it to other people as well. So that's typically the types of IP provisions that we see in research agreements. Now, we deal with all kinds of different sponsors, but basically the 800-pound gorilla is the federal. You know, faculty get grants from all over USDA, NIH, NSF, Department of Energy, Education, etc. All of those are pretty much, there are exceptions, but most of those are governed by Vital. And Mark went over Vital a little bit, and that's where basically the federal government through these awards gives us basically the rights to keep IP as long as we elect it and we disclose the invention first. We elect to have title. We grant the government their rights to use it for government purposes, and we also grant them margin. So as long as we do those things, we can have that IP, anything that comes up from that project. So basically, we're cool with the government's rights under Vital. So that's generally not a problem with federal sponsors. Every once in a while, we do get someone where they want to have ownership of IP, and those are really highly unusual. Usually there's something else going on in that situation. The next sponsor that we deal with a lot across the system is the state of Texas. You've probably dealt with jury awards, General Land Office, Comptroller's Office, Texas Parks and Wildlife, Commission on Environmental Quality, etc. All of these different agencies. It varies from agency to agency. Generally, one of the issues that comes up with IP and dealing with state agencies is sometimes they want to open it out, which seems a bit strange because, you know, we're all brothers and sisters, we all work in the state of Texas, but they want to own the IP that's created by the funding board, or they want to have joint ownership. And joint ownership generally isn't as problematic. Sole ownership is a little more problematic. We have to go back and forth with them on that because, you know, and this has actually come up in Mark's episode, is that if something is invented and they own it, they generally don't have a way to commercialize to bring it out because they're not set up to do that. We have innovation offices to do that. So that's one thing we try to, you know, inform them of. It's like, you know, at least with joint ownership, you don't really have the ability to deal with this. I was going to bring up just a little bit. I was going to talk about for-profit industry agreements a little bit, but also one of the interesting things that we've seen more and more lately with nonprofit entities, you know, American Heart Association, American Cancer Society, American Chemical Society, which I'll talk about a little bit. They don't necessarily want to own an IP, but typically they want to have one or two things. That you want to have some kind of revenue sharing. So if there's something electrically comes out, they want to say, okay, we want to share the revenue from this thing. Or they'll say something to the effect that anything that's invented, you have to give away to the public for free. And while that's some dynamics, it can cause motivation as well. But when you're dealing with industry, you know, for-profit companies, typically, almost always they want to own it outright. That's their starting position. Is that anything's created, we want to own it. Barring that, generally they want some kind of exclusive license to it. They don't want to own it, they want to basically be the only one who can commercialize it. And they also, because of this exclusivity, they want to limit what the system member can actually do with the IP going forward with anybody else, because they don't want to have it given to their competitors. Now, our system policy for all system members is governed by System Regulation 17.0101, and this basically says, you know, any IP is created by an employee of A&M while in their performance of their duties is owned by the system. And if it's created jointly with someone outside of the system, then it would be jointly owned by the Texas A&M University system and the third party. So what we try to do as contract negotiators at SRS is we try very hard to negotiate IP language that's in line with this system policy. And basically what this boils down to is, you know, if you invent it, you own it. If we invent it, we own it. If it's invented jointly, then it's jointly owned. We have to seek higher approval for anything that's outside of basically this format. So for instance, if we have an award that grants a non-exclusive royalty-free license for an outside third party to use any IP we come up with for non-commercial internal research purposes, that's fine. We can actually do that without having to seek higher approval. Or if it's, as I discussed under Federal Government by Dole Act, basically if you grant the government rights to any intellectual property, then that's fine as well. But anything above that, we need to seek higher approval. And that's where we bring in Pete's office, because we need to see, okay, IP of value that we could potentially risk losing if we were to agree to some of this troublesome language. Now, I was going to kind of go over just a couple of different agreements that we see that can cause a lot of problems. And this is something that, you know, as faculty, when you get these agreements, this is something to be aware of. One of them is a work for hire agreement. We've seen that language a lot and have to deal with that. We try to negotiate out agreements. Testing or research services agreements, those are agreements that typically, they do serve a purpose and there's a time and place for them, but we have to be careful how and when we use those. One of the things I've seen more and more with foundations is basically requirements to give away any intellectual property for free, which, you know, carries its own set of issues. And another thing is basically we've seen in kind of on the proposal side of things, where basically when you're proposing to do research with a company, they'll actually want to use whatever data you give them in a proposal, whether or not it's funded. And that's something that's also kind of be on the lookout. Work for hire language. But this is an example of a typical language you see in work for hire. Basically what it says is, in a nutshell, anything you do under this contract, we own. Copyrights, intellectual property, everything. And the issue with this is, you know,
we need to
yeah, when I say, yeah, sorry, I misstated. Basically, when I'm speaking from the sponsor standpoint, whatever you create, the sponsor owns. Period. And one of the issues that this actually can cause a real problem for faculty is work for hire is all inclusive. Copyrights, journal articles, anything that's created on that project, the sponsor owns. And if typically under A&M policy, anything, you know, scholarly works, articles, things of that nature are owned by the faculty member, so that they can give that copyright to the journal and get things published about it. Under a work for hire scenario, that's not the case. If it's truly a work for hire, then they actually own the copyright on anything you produce under that award. And that's one of the issues that we have with this, is it can prohibit publication for students in a thesis, you know, faculty can't publish unless the sponsor says yes or no, you know, issues like that. So typically we don't want to agree to work for hire if at all possible. You know, basically we don't want to be giving away IP. And, you know, that's not our mission. Our mission is to get things out there and to broadly disseminate knowledge, and that pretty much prohibited that. And this is not advantageous for the faculty or for the system to do something like this. One of the issues that we also have a problem with in doing a work for hire type arrangement is, you know, you're giving away IP for free. And one of the things I wanted to bring up a little bit is the issue of the tax-free bonds. That, you know, one of the issues you would say, well, why can't you give things away? As we're a state-funded entity, we are supported by tax dollars, and part of getting those bonds to pay for things is to say that we can't use these things for private benefit. If we're basically doing work for a for-profit sponsor and we're giving them intellectual property, we are doing private work with public facilities, and that can cause an issue that we want to avoid at all. So when we get work for hire language, we try our very best to remove it. We try to reason with the sponsor and say, this really isn't a work for hire scenario. And typically, when they're dealing with other companies, is what they're used to seeing. Is, you know, they do a work for hire for you. We're just contracting. Pay you, you do the stuff, give it to us, we own it. So we try to explain to them that we can't do that. What we try to say is, okay, if we don't give you the ownership over this, we try to say, okay, we can give you licenses. We'll own it, but you can have rights to use it. And most of the time that works. However, there are some times that basically the sponsor is, you know, ironclad, they will not move. And that's something where we really have to determine, and, you know, basically the system member has to make the decision in conjunction with the innovations office, is this something that can go forward? If there, you know, probability of developing intellectual property and publications is slim to none. Another thing I want to talk about a little bit was testing research services agreement that I mentioned earlier. And this is a case where we're performing a true service for an outside party. Like, for instance, I have some of the examples I have here, you know, we're testing water samples or we're testing soil samples that someone brings into a lab here. And all we're doing, we're testing those samples, we're getting the results from the machines we're running through, we give them the results. That's all we do. And there are a lot of facilities on campus that do that kind of work. In that case, we could use something like a testing research services agreement. And this is, or another example is, we're conducting an analysis of some kind of product according to a protocol that the sponsor has provided. They tell us exactly what to do. We follow the protocol to a T, get the data, give it back to them. That's a testing agreement. Typically, we have language in, I have it shown here. This is our work product language. So basically, we can give them ownership of the data and all of the results and all of the analysis that we get out, because we're not creating any intellectual property. We're just basically testing something, giving them the data. However, we do usually hold back a right to publish because we need to reserve that right as a public institution of Texas. But the reason that we have to be careful with this is, I said before, we need to make sure we truly are just doing testing and we're not going to be doing research. And what I have seen happen sometimes is we'll start off in a testing scenario with a sponsor where they're actually come in and they just want you testing samples. That's fine. But then it will morph into more of a research agreement where they say, oh, we have this problem that we're trying to fix at our facility and we want your expertise and knowledge to fix this. But then they'll want to continue to use language I can use in the testing. So we have to be very careful to tailor specifically to the work that we're doing. So, like I said, there's a time and a place for using these type of agreements, and we have to be very careful using them in the right scenario. One of the things that I mentioned also that we see a lot, grant of free public use. And this is seen more with nonprofits. The language I have here, italics, is basically language we've seen, for instance, from American Chemical Society. And basically, it's saying that anything that's patented under this work, we give it away for free. And this kind of language, while noble in intent, it significantly limits the ability of the system to commercialize anything that comes out of this work. So we can't accept grants like that. We usually have to be very, very cognizant of the fact that if something is going to be developed that can have commercial potential, we might not want to do it under this work. Like I said, this is a specific one that we've dealt with very recently. And we see it more in the nonprofit sector. Another thing that's come up more recently is we're seeing more and more sponsors, especially corporate sponsors, that they'll send out a request for proposals. But in doing so, they'll make it very clear that one, any data you submit to them, if it's going to improve their product, make things better, whatever, they can use that, whether or not they fund your proposal. And two, we also have to agree to certain IP terms up front before we even would get an award. So this is something that we're trying to let faculty know about when the award is submitted. Sometimes this isn't the fine print, and you don't really know that this is what you're signing off for. And I've had a couple of instances recently when we made the professors aware of what was at stake, and actually decided to decline that submitting that because of that. I mean, there is a place for that. Maybe it's a truly public benefit thing that has limited commercial potential. So, we work. That's kind of just sort of in a nutshell the kinds of IP that we deal with in the sponsored research world. So, if y'all have any questions, just let me know.
Well, let's leave it there for a moment, so because yes, please send in your questions. Travis will be part of our panel. I'm going to leave that slide there that has the QR code. I did want to highlight a point that Travis made that getting the intellectual property language right is certainly important to our office and to the system relative to commercializing. You made a good point that it can bind up your future research in a potentially career complicating kind of way. So it really is, Travis and his colleagues, and we work with them closely. We are really doing that work. I know it can sometimes take some time to have these negotiations, but it really is important to get it right, or else there could be some unpleasantness down the road. Our final presenter is Janie Hurley, our Senior Director for our licensing team. that means is that she leads our licensing team of 11 licensing managers. Jane's been with the system many years. I'm always impressed and warmed when people get to see her who haven't seen her for some time, the warm greeting that she brings. And Janie will talk about innovation, our intellectual property related to our office. So thank you.
Let's get that terrible picture off as quick as I can. Howdy.
Howdy.
Thank you for being here. I'm going to give us a bit more kind of diving into how Texas A&M Innovation protects intellectual property, which we will also, of course, be talking about commercializing technology. So I want to start us off with a refresh of the mission statement for the university system. How many people realize that commercializing technology was in the mission statement of the system? A little surprising, right? And we see research and education there, we expect that, but there's also commercializing technology that is part of the mission statement of the university system. But how can we commercialize technology when we're a university? We don't sell products. And so that's where protecting intellectual property comes in, because protecting intellectual property provides us a means for commercializing technology. We are then able to work with companies to get products developed, and it's a little bit more about that. So part of the reason, again, is just building our mission. It's right there in our mission statement as to why we protect intellectual property. And again, to be able to get a product developed, we're going to do that here at the university. More development is going to be needed, and so protecting IP actually enables us to facilitate that translation of the research results to the marketplace, because it gives us a piece, an asset that we can actually transfer rights to industry. So when we have that asset and we transfer rights to a company, then that also enables us to capture value back in return for transferring certain rights in that asset to a company. So where does the process start? It starts. We have a very experienced team of licensing professionals in our office, a really consolidated office. So there are about 11 of us right now, and hopefully we'll be growing. So you can contact any of our licensing folks in our office at any point in time. We do have an invention disclosure form. Well, we do have different types of invention disclosure forms. If you go on our website, up there are forms that are specific for plant materials, if you work with plants. There's software, and then there's a normal, just kind of for everything else, I guess, invention disclosure form there. And largely it's going to be asking questions so that we can gather information on what your technology is, so we can initiate the process. So just to be clear, this is an internal document. Disclosure forms are not sent over to the patent office. It's for our purposes, for us to begin an evaluation of the information that you provide. So questions about, it's going to ask questions again about what your technology is, what problems does it a certain need, and how does it compare to things that are already existing, those types of questions. And then it will ask about your results. What have you done in the lab to show evidence that you have tested whatever your technology is? So you may recall that Mark mentioned conception. So it's not really just having the idea, but when you look forward to working with the patent office and trying to get a patent on your invention, you're going to have to show the patent office that you actually possess the invention. So if you refer back to some of those comments that were in the slide, it said a specific and settled idea that doesn't require additional experimentation. And so just know that we'll be looking for some of your evidence and results that you have in the lab when you tested your idea. So it's also going to ask you questions about some of the background and how your technology came about, what particular funding that you use, any materials, outside materials or information that could have come from a third party, because that's going to tell us whether or not there may be obligations to another party that we have to factor in. And then it's going to ask about who the contributors were and the extent of their contributions, so that we'll know who the appropriate contributors are to the technology. And then there are questions related to public disclosure. I'm going to go a little bit more into public disclosure simply because this is an important item that can have an impact on our potential to get intellectual property protection for an invention. So I give a few examples up here. I mean, it's pertaining to things in writing and verbal that is shared outside of the university system about your invention. So if you're giving detailed information, which we refer to enabling information about your invention outside of the A&M system, then that can have an impact if you have not already filed for intellectual property protection. So that's something that's really important for us to know as part of the disclosure. Social media posts, that includes, I mean, it really includes anything that is out there that the public could get a hold of. So, and most of these things, I have had examples, real world examples where we found something that had been put out there, released, ahead of us even receiving the invention disclosure. Just real briefly, one of the hot topics recently has been AI tools and what about using AI tools. I'm by far an expert. I know very little, honestly, about AI tools. I'm not a software type person, but we know from looking at some of the things that have come out in the press lately that you have to be very cautious when you're using AI tools there. I don't know if any of you have seen, there was an example in the press that came out of Samsung employees putting in sensitive code and meeting notes into ChatGPT, for example, and then later it was determined that that information was potentially considered a fake. So, because the best I understand it, these tools are using information that's inputted into them to learn and to get smarter, I guess you'd say. Well, where's that information go? Is it being stored somewhere? And so, although we don't have the answers, it's just something we want you to be aware of because it can be a problem. It can represent a problem when we're talking about trying to protect intellectual property. So, so once these questions are answered, we get the invention disclosure. Our team receives that and it gets assigned one of our licensing professionals to take a lead on evaluating the new invention or technology. This is a two-part process or evaluation. The one part is the intellectual property. These are some of the questions just to try to help you understand the things that we have to think about and look at. First is, does the A&M system even own the technology? So, are these A&M employees and resources used? Then likely it is going to be owned by Texas A&M. Does it meet criteria for protection? If it's something we're considering to be potentially patentable, it has to be new and useful and not obvious. I mentioned enablement. You have to show that you're in possession of the invention. You can't just file a patent application on an idea. It has to be tested out. So the other thing is potential scope of protection. Sometimes it could be that, yes, it is inventive, but it may be something that is so narrow, we could only get very narrow protection on it, and therefore probably not interest the company in the technology and taking rights to the technology. And we think a lot about timing. And that is a little bit back to your public disclosure. Have you already published or are you intending to publish soon? If so, that's going to affect our timing, and I think it's important to seek protection. Sometimes it could be that you have some preliminary results, but you were planning to take it into maybe animal studies. And that really won't serve our application if we file for patent protection. So it may make sense for us to wait a little bit and to get those results, that kind of thing. And then engaging to seek patent protection. We don't have patent attorneys in our office, minus Mark Kelley, who's really in the general counsel's office. But we work with outside counsel to handle the preparation and on the patent applications. And so, our licensing professionals are familiar with these attorneys. We try to meet the technology best we can with an attorney that has the right background and experience. And then we also have to think ahead as well about enforcement. And so even if it's something we can get patent protection on, is it something that a company would be interested in because maybe it's a method that no one would be able to tell that someone was practicing maybe in their lab without permission, and you just wouldn't know. So the patent protection is only as good as you can enforce that protection. So I said it was kind of two-part because at the same time that we're thinking about these intellectual property protection questions, whether or not we can protect the intellectual property, we also have to think about the commercial potential. Because as I said again, as a university, we're really looking at protecting intellectual property as a means of being able to commercialize technology by working with companies that can actually take a product or develop a product and market a product. And so we have to consider these other things. What's the commercial potential? What are the various applications? Sometimes there are things that you already have in mind when you make your disclosures to our office. Sometimes our licensing folks may help you think of other things that the technology could be used for. We think about the market, is there a market need? Is there an obvious market need there? Or is it something that we would have to investigate a little bit more to see if there's a market need? Who's going to be interested? Again, we're going to have to find companies that could be interested in the technology. And so sometimes you may already know companies, sometimes not, and that's okay. And that's one of the things that we do with our licensed professionals. And what's the market size? That's always a factor. Thinking about scalability, of course, things work really good in your lab setting, probably, or you wouldn't have brought it forward. However, we also have to begin thinking about that next step in a commercial setting. Is it scalable? Is it something that you're using a reagent that that's just a small quantity, but it's really costly? And when you think about scaling it up in a commercial setting, it's really not going to be economic. And then what are the barriers to commercial adoption? So sometimes there may be an obvious piece of intellectual property that another party owns that would be required to practice that technology. And is it something that it would be accessible in some way? Are there regulatory approvals that are going to be required for the technology? We have to think about those things. Again, it's all prepping us for positioning ourselves in taking something to market, again, by approaching companies. And so we know these companies are going to be asking these questions. And so we want to have already thought about those questions and address them the best way. So just kind of wrapping up, what are some of the benefits of protecting intellectual property and commercialization? And hopefully our goal is we want to see more discoveries reach the market. And so where it is possible, it doesn't mean that every research result really makes sense for us to take through the process of protection and commercialization. But for those that do, then we can potentially shepherd things through and help things get to market and ultimately become a product. That's our goal. So also in going through this process, we end up establishing relationships with companies. And a lot of times these are long-term relationships. We look at these transactions of commercializing technology as entering into a relationship with the company. And a lot of times we may end up licensing additional intellectual property to the same company, or we may also have that company interested in some of our research programs and fund research. So we really are very attentive to the relationship aspect. Promoting economic growth, I mean, ultimately, if a product comes to market, and that could be through an existing company or perhaps even a new company, we feel like, we're promoting growth, economic growth. Hopefully, we are incentivizing faculty as well to participate in the process, because the policy has a portion of it, like commercialization revenue comes back to the inventor personally. And so that can be a real attractive point for faculty. We have it all the time when there's potential for new faculty coming in and they want to know, what's the policy for sharing revenue back to the inventor. And then also, again, working with companies, hopefully we're seeing that additional research is coming back to the university to support research and education. So sometimes we get asked, final promise, how do I know when to disclose? And I just have a few thoughts here about, proof of concept. When you have something, you've got proof of concept and you think, hey, this seems like it could have some commercial applications. Or if you're about to publish something, oftentimes if you have some really nice results and you just can't wait to get them out to the world, and you realize it's something, hey, I can see a company being interested in this. Great time to disclose. Contact our office if you'd like to talk to somebody before filling out the form. Always welcome you to do that. If there's an unanticipated result that you think may have value, most of the probably most valuable inventions are usually coming from something very, very unexpected that happened in a lab. And then sometimes it's a company reaching out that you may not have been prepared for, but they've seen, your work, and maybe it's a publication, and they see what you're doing is interesting. And so, contact us and we'll see how we can help. If it's something that has, some potential and company interest, we're glad to help. And that's all I have.
Thank you, Janie. We talked about AI a couple times. Just as a revisit. From a perspective of creating intellectual property, AI cannot be an inventor. Material created by AI cannot be included as invented subject matter. Separate discussion is submitting information into AI tools like chat can possibly be considered a public disclosure. Janie is a modest person. She's modest on this topic by claiming she's not an expert. It's not clear who is an expert on this topic of what constitutes a public disclosure for AI tools, which is why we are, in our role, just providing a word of caution. AI tools are powerful. They're going to become more powerful. We're not in any way suggesting not to use them, but be cautious. If you put information into AI tools, it may be a public disclosure. So with that, we're going to leave this up here. We're going to move to a Q&A phase. If you're in the audience and you want to ask a question, we won't ask you to jump through the gyrations of sending it to me. We can do that in the whole school. Just give you the microphone kind of way. I do have a number of questions that have come in already. So are we going to be able to move? We already did it. So I'm in. You guys already moved the camera. Awesome. So, first question, and I'm going to target my questions as a member of the panel. Please, let's make this as conversational as possible, so if you have a thought that's not directed at you, please go ahead and jump in. Janie, you still have, are you guys gonna pass that?
Yeah.
So Mark and I will pass this one, and you guys will pass that one. Outstanding. So first question, I got targeted for Mark. Mark, you talked somewhat about the time to get a patent. Talk about the cost with some of the different kinds of patents that happen, and maybe some of the steps in the process.
Normally, we here tend to file a provisional patent application, which is kind of cheap. That can be, with outside counsel, can be anywhere from about $500 to $100. But then a year later, when you're doing a non-provisional, it can get higher up. You're talking several $1,000s. And if you try to go overseas and get patents, that's where it gets very expensive. You can spend hundreds of thousands of dollars patenting all over the world. You may not have a market for it. For example, Japan has a scale that each year you have a patent, you have to pay almost double what you did before on the maintenance. So they're incentive, if you're not making a whole lot of money on that patent, you better get out. So that's what they do. So you can spend around, hundreds of thousands of dollars for a worldwide patent. So you got to make sure that technology will be licensed that. But in the US, you got provisional, you got 1 year to file on non-provisional. And then that can take 3 to 5 years to come in. That lifespan is 20 years from the date of filing. Then you have European, then you have European ones, you call PCT first, and that gives you 30 months delay, or you have to go to what's called national stage. And then those get filed on the world.
So thank you. And to be clear, Texas A&M will cover all the patenting costs for vendors. That being said, and we have strong, significant support from the chancellor to grow the number of patents. But you can just imagine the breadth of Texas A&M. We still need to be judicious about what we do, and we are, but we are absolutely tasked with growing the number of patents. The next question is for targeted. Before I move on, did Travis or Janie have anything to say about costs? Started at Janie. So we use the word disclosure. Disclosure to our office, good. Public disclosure, bad. So I think you touched on those, but at the risk of repeating, if you could take a moment to revisit the distinction between disclosing to our office and a public disclosure, some of the things you talked about.
Right. Okay. So the form that we use to capture the information on the technology for the first time, we refer to as an invention disclosure form. So and as I mentioned earlier, it is an internal document, and really it's just for informational purposes for us to kick off our process. That is not something that is filed at the patent office. It's not giving, putting a stake in the ground at the patent office at all. That's an additional step. Public disclosure, when we refer to that word, is release of information openly usually outside of Texas A&M. But it could just be in a public setting, and sometimes that's happening at Texas A&M if it is an event at A&M where it's open to the public, and really anybody could be coming in. So that public disclosure is referring to just openly talking or sharing information in written form about your invention.
I want to add something too, is that if you're careful, disclosure inventions to students who are not grad students or not hired, they're considered public as well. Be careful about that.
Well, I was going to add to that, and this is where the distinction comes in our world, is what type of students. Some graduate students are employees, so they'd be just like something else, but then undergraduates, none of those are generally no. You think of a case where it would be
Sometimes they're hard,
like a student worker or something like that.
sometimes
Yeah.
they're.
For the most part, undergrads would not be employees, you're right, if you disclose to those guys.
Now, pull up that microphone. Does the amount of research support dollars affect IP rights?
Yes and no. I will say this, I mean, we see companies fight over IP rights, and we're talking about $5,000 to $10,000 awards. And we also see it for $1 million awards. It varies, but a lot of times, people will say, well, this award's not worth very much money because really, IP rights don't matter, but it really matters what the project is doing and, the potential for, something to be developed out of this. So I guess the question, it affects the way, like, if we're getting a very, very large grant, then there would be a way, what's the potential for IP to come out of this? Is it worth the money that we're being paid for? Something along those lines.
Yeah, and from my perspective, you said it exactly. There are contracts that come through for very long, small dollar amounts, 10,000, a few tens of thousands, that still have very onerous IP rights, the same as could be on something that's very many millions. For our office's perspective, we do have a business perspective of the analysis of these, and if there's enough money in the sponsored research agreement, you could say, well, that could be worth it. That being said, a technology to reclaim lithium from waste materials in a way, and therefore unlock a massive new source of lithium. I'm just throwing out an idea that I've seen recently. That can be worth more money than any sponsored research agreement we could ever dream of. There are places that have, the famous example in our world is Gatorade. I guarantee you the people that thought about helping the performance of the football team at the University of Florida never envisioned the amount of money and the entire industry that would come out of that. And if they had not been thoughtful about how they handled that, none of that downstream financial benefit would have helped all of that research that has continued to happen at the University of Florida. And I'm presuming the inventors of that doing some really fun stuff with that money. This question came in a while ago online, so thank you for submitting it online. I'm going to read the question, and I'm going to, at the risk of interpreting the question, if somebody recorded a new activity for a particular compound that already registered as a patent, can we consider this new activity as an innovation? And it relates to a question about how to extend patents. And so, Mark, I'm going to target this question at you from the perspective of just share a few words about some of the mechanisms. So you talked about the straight line, file a provisional, file a non-provisional office actions. Can you talk a little bit about some of the derivative kinds of things that can happen? I know we're not here to do a deep patenting course, but just give a touch of some of the different forks that can happen. And I think maybe that's what's happening. Thought here is, if there's already a compound registering, can we consider a new activity related to an existing, and there's another part maybe just touch on, is work that, patent work that can happen prior to a patent issuing, and then the restrictions that happen after a patent issues, and then becomes our own prior art. And that's a lot, so.
So when you have patenting, you have variations. You go through, you can come up with something new, and you can follow on as a continuation of part. You add new matter to your patent, and you follow on a patent application. However, that's subject to prior art that comes in before you follow this new matter. There's different things where you have restrictions. I mentioned before, PTO can come in and say, you have two inventions, I want to make you restricted. And so you follow provisions. The other one is you come in there and it's like two separate patents for two different technologies. You have a continuation where you're going after something and the examiner says, I'm not going to allow that, I'm not going to allow that. So you drop those claims, you follow the continuation patent, try to see those terms separately. Try to see the different patent examiner. If you're lucky, sometimes you get the same on patent. So those different ones there have other patents that are filed. People in the same institution, you get a restriction requirement and term disclaimer requirements and term of patent things. So you file a term disclaimer, but you have two different patents around there and still around, and they may be different vendors, but it's all commonly owned by the system. For new use, I guess they're asking about a used drug, chemical. Some of them are allowed, some of them aren't. I hate to say this, but words will use this. It really depends on the facts. So that's when you need to disclose it early and bring it in so that everybody can examine what are you trying to do with it. That's the problem is even if you may have used the underlying chemical who has patent on that, you commercialize it. Sometimes is an issue. Because you may say, hey, I think this is a great thing, I made $80. That's something on the product itself, and they won't license it to wherever you want to license it to. The good parts of that point is always.
I know there's a lot after there. An element of a potential part of the patenting strategy would be to keep some part of the patent alive. What I mean by that is once a patent issues, then that issued patent will actually can be used as prior art against your own future inventions. And so, again, there's another question about how do you extend the patent life. That's why drug companies are famous, because extending the life of a drug by a month or a year for a tremendous amount of money is ways of doing the things that Mark talked about are much more possible before the patent actually issues versus once that patent issues, and if you don't have any other forks of that patent alive, then that becomes actually prior against you. So that's why when we identify a patent that has very high value, it will become part of our strategy to keep some part of that alive, even if the first version of claim is in condition. Yeah, go ahead, please.
The only thing, even if we can keep it alive, it does not extend the life of the patents. You get 20 years from data filing, you can do these other continuations, and you say you got 11 years to take it and how in the PTO, when it comes out, you got 9 years left. So it doesn't get 20 years for every patent filings, depends on what they claim prior to.
So Janie, do you mind speaking a little bit about back into the forgive me, I'm not asking the same question again. Non-disclosure agreements and provisional and utility patents and the right way of handling those with people external to Texas A&M.
So,
We'll solve it this way.
okay, so I mentioned about public disclosure and that can have an impact on patentability. And so what we will often do is if there's a need to disclose to somebody the information on your invention prior to this filing a patent application, then we can enter into a confidentiality agreement or a non-disclosure agreement with the other party, so that then we're establishing confidentiality within the parties regarding that exchange of information. So it doesn't mean that we can't engage with the party before a patent application is filed, but we just kind of need to go through the rights with the events before doing so. We use in the U.S. very often the mechanism called a provisional patent application filing when we decide that that's the appropriate thing to do. And that provisional application does establish, I guess, a statement around, if you will, with the patent office regarding your invention, and you get a filing date. But it's not examined. It sits with the patent office. It is on record with the patent office, but then by the anniversary date of that provisional application, you need to have decided if you're going to go forward with a full utility application to continue your attempt to get patent protection. And it's once you file that full utility application that the application gets really kicked off into the queue of the patent examiner to begin the process.
Thanks. Travis, can your office help with data security questions?
Yes. Data security typically, we're going to be here. Typically data security, I mean, we have data use agreements that typically our office handles, especially for Texas A&M, Texas A&M Science Center. Some of the other member offices handle data use agreements for TVs or for AgriLife. So it is a little bit parsed out. So SRS doesn't handle all of those, but typically those type of agreements would deal with, you know, how to keep data secure, what data is being transferred, and actually you've kind of seen an explosion in those type of agreements in the last 5 to 7 years, with people being more cognizant of the value of data. And you know, because there is a lot of value in data. So when our researchers want to obtain data from someone else, or someone else wants to obtain data from our researchers, it's very good to put something in place that says, how are you going to protect this data that we're giving you, or you know, what can you do with it? Because if there's not clear language in a data use agreement that describes what you can and can't do with it, one, you could lose valuable data. But two, you could also run afoul of the law if we're not protecting, for instance, personal data, or the party that we're giving to is not protecting it like they should. So there's two things we need to cover: is, you know, the legal aspects, and also, you know, protecting valuable data that we have, or you know, we have to do our job to protect data that we're receiving. So, in short, yeah.
So I've got one or two more questions. Is anybody in the audience brave enough to come up and talk to the microphone and ask a question? I don't mean to suggest you're not brave if you don't do that, but forgive, or maybe I should say, I forgive me that I implied that. So, no, okay. I'm going to combine a few questions, and so this will be the last question. So there's a few questions that we received. Actually, there's one more after this, related to some different kinds of potential inventable, protectable subject matter. Design patents, computer model systems, software. I have a question about digital images. And so this is sort of a jump ball for whoever wants to jump in. Share a few thoughts about some of the different kinds of intellectual properties. We focused a lot on patents. That makes sense. That is a significant, vast majority of the work that we do is related to patentable subject matter. But can somebody jump here and talk about some of the other types of intellectual property that come out of the work that happens at Texas A&M?
I agree with you, strong. So there are three different types of patents when we're thinking about patents. The utility patents are the most well-known and in use. Then there are design patents, which really protect as it says in the name, the design of something, not functionality. If you're trying to protect functionality of something, you have to use a utility patent. Design patent is really strictly only the design of something. We do very little design patents. There are plant patents as well that protect asexually propagated plant material. So those are the three types of patents that we see here in the U.S. Then there is plants, I deal with plants, so there is a mechanism through the USDA, not the PTO, that is plant variety protection certificates, and so those have been for sexually propagated plants, although in the last couple of years they actually added asexually propagated plants to the mix so that you can get what we refer to as PP protection on plants. And then we also think about copyright protection. We don't do an awful lot of copyright protection. When we do, it is often comes from software. Software can be patented, but we have to ask the question if it makes sense for us to patent software. Because technology moves so quickly. And a lot of times we have to look at the cost and say, well, this is going to be obsolete by the time that, we even get the patent issue. And so we file to do copyright registration for software, which is actually one of the patent protection. There are trademarks as well. That's another form of intellectual property protection, but trademarks are connected to the commerce. So that's really more often a company that is going to be interested in trademark protection. We do have some trademarks that we have filed on in association with another invention, usually plant materials and things like that, because then we can convey the rights in the intellectual property protection, the PEP or the patent along with the trade, and require that the company use that trademark in association with it. So we do that. The other form of protection that we use sometimes is contractual, which also often happens with plant materials in instances where we may not be able to get a plant patent or a PEP, but we can just simply through a contract actually protect our rights. It's a little more risky because if something happens and the company violates the contract, well, your recourse, that's a little questionable there. But it is another way that we end up protecting the intellectual property.
Just did notice in my head that we tend to do combinations. So like in software, sometimes we patent the whole copyrights to do different enforcement actions. So if I file early in copyright, we'll give them copyright software, which is cheaper than trying to go for a patent lawsuit. To go to a patent, it's usually to get what we call bargaining, which is the first guarantee of the claim fee, costs you $650,000 just to get that on the stage. So you better make sure you don't get enough money coming from the patent to sue to justify it. Whereas copyrights, it's a lot cheaper to go in for someone else.
Thank you for jumping in there. Two quick questions, and I'm going to try to handle myself. One is rough percentages of the TAMIS portfolio that are granted patents that are TAMIS only, TAMU industry, or TAMU nonprofit. I don't know those numbers. Janie, do you know those numbers offhand? The vast majority of the work that we do is the A&M system is the sole assignee of the intellectual property. We're certainly very open to collaborating and joint intellectual property, but that almost always makes it more complicated. And so to the extent that that we can be precise about what our intellectual property contributions are and focus on that, that's the way we will do more of our work. The second question here is provide some discussion of start to finish step-by-step process of engaging with the A&M Innovation Office. Nowhere near enough time to do that here. I would point people to our innovation website. If you Google Texas A&M Innovation, we'll take you to our website. Under the Inventor page, there is a rough process flowchart there that has some descriptions of each, a short description of each step in the process. Also under the Inventor page is a downloadable Word document version of the disclosure, the invention disclosure document, so you can find that there. We are working on adding more resources to our website, such as hopefully people view the recording of this session as a resource. We will be adding this to our website. And so please go there. If what's there doesn't answer your questions, please get in touch with us. So with that, last offer to the audience. Any other questions? You have a question? awesome. Hold on. Well, do you mind coming up just because? I don't know where the camera is, but standing here, you'll be on it, so.
It's actually related to public disclosure of my question is related to public disclosure of information that could be connected to a discovery that has value in terms of being protected. It happens often that there is research that ends up leading you to the discovery. So portions of that research could have been shared at meetings, professional meetings, or you're getting ready to prepare an abstract or even a publication. Is there a time frame? I mean, if some of that information is housed, maybe not connecting the dots to make it an invention, but some of it is out. Is there a time frame that we need to be cautious with?
Yes, so of course it depends on which type of information and what technology we're trying to protect. So in the US, we have a series of years to file a patent application from the time that the enabling information on your invention was disclosed. In most other countries, there are a few exceptions, but most other countries do not have a grace period. And so once the invention has been out, in the public in some way, then there's an opportunity to go back and file for a patent application. It is, since I know you work in plants, it is different with plants because seeking protection for the actual plant materials, it is more about access to the materials rather than information. And so we do have a little bit more flexibility when it comes to plants because if we have made the plant material available publicly, well, actually release it or transfer it, but not under, some kind of agreement, then we still have quite, we have plenty of time to file. It's more about offering it for sale and those kind of things. It's different.
Could I ask one more question?
Yes.
Okay. Many of you are directly involved in the Texas Innovation Office, but I know changes have happened in the recent past, and I think not everybody is really aware of what the implications are on the line. Like you mentioned and emphasized how important it is to have the inventors engaged, because there is motivation to move forward. But back in time, there was also huge interest in investing in research programs, and I was wondering if you could share some of the new trends or ideas that the office has.
Well, that's a potentially long discussion. And so you're quite right. Earlier this year, 5 offices around the system that supported intellectual property were merged into one, became Texas A&M Innovation. The motivation for that was to elevate Texas A&M's innovation activity across the system. And yes, that has some potential impacts at some of the individual members. If that's what you're asking about, let's have some follow-up conversation about that. I would, from my perspective, understanding that I joined Texas A&M the same day that merger happened, technically one day earlier, but effectively the same day. I really see that as a follow-through of the support from the highest level of Texas A&M, the chancellor, then President Banks, now President Welch, many other leaders, to really increase Texas A&M's support of, and therefore, hopefully, and the expectation is the results of commercialized activity. And measured in multiple ways, measured in, some of the intermediate metrics of numbers of patents filed, numbers of companies formed. I think we in the commercialization world think more about products getting to the marketplace. Products to the marketplace can often also bring with it a measure of dollars, and so I think the dollars is another useful metric. But that is absolutely our goal of supporting inventors to have their inventions translated to the market, whatever the market might be. I don't think that's a very complete answer, but maybe you and I can over the next phase of this event, which is some networking. I've never participated in this kind of thing before, but Crystal from our team has set up the opportunity to have some online networking. I can't offer an adult beverage to people online. We haven't figured out how to make that happen virtually yet, but a couple people from our team will make themselves available for some ongoing discussion. And those of you that are here, please, again, we have some refreshments and drinks, so hopefully you're able to stick around, and it'll be our pleasure to have some additional discussion about these topics. I do just want to highlight a few upcoming events. It is our goal in the Innovation Office to build momentum and with connection to our customers. The next one of our events is a continuation of our entrepreneur networking. It will again be in this exact spot in collaboration with the McFerrin Center for Entrepreneurship in connection with an event that they host before home football games, where they call First Down, those Friday afternoons. So the Friday, November 10th, right here, 5 to 7, a networking event. We will have a couple of our companies present, where you can get a deeper insight into some of the work those companies are doing. There's a McFerrin on tour. Any of you that have the opportunity to be in Austin on the following Monday, November 13th, be pleased to host you there. And the next one of these educational seminars will be December 4th, with the topic being commercialization funding mechanisms. And yes, I am trying to entice those of you here to spread the word that we will be talking about how to get money. And I'm not saying we're going to bring money or any promises of that, but we all know that it takes money to lubricate and cause the results that we need and want. And so we'll be talking about that. So please share the word, spread the word with your colleagues. And finally, again, we will distribute a survey. We need your feedback to tell us what part of this you liked, what part of it we can make better, what part of it we should eliminate. We're here to serve you. With that, thank you very much.